Dear students, we are going to learn express and implied conditions part 2. In the previous module, we have covered 2 points and I told you there are 7 points and the remaining 5 points I am going to explain in this module. So let us see what are the points. Now, third condition is, or the third implied condition is condition as to quality or fitness. So section 16 of the Sale of Goods Act 1930 explains this condition. Now, generally, we have to remember there is no condition as to quality or fitness for particular purpose of the buyer. Because in sale of goods, you know that the rule is that let the buyer beware, caveat emptor. So that is the general rule applicable. If I want to buy a something or if you want to buy a something, it's your duty to find out that. See, if I want to do something, I want to buy something, whoever purchased that product, wherever I can collect information. If it's a huge expenditure, definitely I will collect that information. On that basis, I will take the decision. So it's very important. Let the buyer beware is the general rule applicable. So buyer has to check the details and satisfy before buying the items. It is, as a buyer, it's our duty to verify. We cannot complain about the seller for everything. Now, but there are 3 conditions related to this. First one is buyer conveyed the need and depends on seller's skill and judgment. I want to buy something. I collected the information, but there is a specific purpose I am looking for that. See, I do needlework. So when I am buying a needle, I will tell that whether I want to do the embroidery, whether I want to do the shadow work, whether I want to do the embroidery or the cutting, anything related to that. So the purpose of that I should communicate. So it's very important. Buyer has communicated the need and depends on seller's skill and judgment. So here one case is there, priest versus last. This happened in 1903. So priest was a cloth dealer and he wanted to buy a hot water bottle from Mr. Last. So he went to the pharmaceutical or the shop of Mr. Last and he wanted to buy a hot water bottle. So he mentioned that I want to use this as hot water bottle. We know that hot water bottle, we will use boiling water. Then only we can use for longer period or the longer time, longer duration. So here he mentioned that he want to buy the hot water bottle. Then he has to, it's the duty of the seller to select that appropriate item. The buyer is a cloth dealer. He has no idea. So priest has requested Mr. Last to suggest a good hot water bottle. So the buyer is giving the request to the seller. Then, but after a few days, when the buyer used that hot water bottle, it bursted and his wife got injured. So bottle could not be used for hot water, could be used for hot water, but not for boiling water. But generally when we buy a hot water bottle, we will use the boiling water. So there is a breach of implied condition because you have to remember each case is different. Here the buyer has mentioned his intention. He told the seller that I am ignorant, I am from a different field, I am a cloth merchant. You are, with your knowledge and skill, you have to specify the item. In that, the seller is suggesting that hot water bottle and it came out to be a faulty one, what he suggested. So the seller was asked to pay the compensation. Second case is Baldry versus Marshall, 1929. So here, Baldry, buyer conveyed the need and depends on seller's skill and judgment. So here, another case, this happened in 1929. Baldry went to the car dealer and asked for a suitable car for touring purpose. See, vehicles when we purchase, some will be buying for commercial use, some will be buying for personal use, some will be using for touring purpose. So all this, so here the intention was for touring purpose. So Marshall, the car dealer, recommended Bugatti car, but the car was unsuitable for touring purpose. So Mr. Baldry could reject the car and recover the price from the seller because he has mentioned, buyer has mentioned the need, why he want that and what is the purpose. So the seller has to suggest a suitable one according to the buyer's request. Now the second point related to this is that if the buyer is purchasing a special item and it is not made known to the seller, if you're buying something special item, see for example, I want to buy a medicine or a cream, but I am allergic to some medicines. Then I have to specify that I am allergic to that. See, if I am buying some medicine, my heart ailment or cancer or anything like that, I have to deal with or I have to discuss with or I have to mention that to the seller. Anything is something special. See, if we are buying something, a child product, because the child is special child, then you have to mention that. So that is the duty of the buyer to communicate that to the seller, because you are buying an item, a special item for a special purpose or for a special person, a person suffering with something. So then the implied condition of fitness does not apply if the buyer has not communicated that to the seller. Here also one case is there, Griffiths versus Peter Conway Limited. This happened in 1939. Here Griffith purchased a tweed coat. So here he has to mention that coat it's for wearing. So this, he is sensitive, his skin was sensitive, and the request was not communicated to the seller. Sensitive skin. The buyer has got sensitive skin. This is not mentioned to the seller. So the item, what he sold was, it was suitable for normal skin. So the implied condition of fitness will not apply, because here the buyer has not communicated the special case or special purpose, special need. Then only the seller will be held responsible. So in this case, since the buyer has not communicated, seller is not responsible. Now the third point is buyer purchasing a patented product or branded product. When you are going for a patented product, the assumption is that you have got the information about the product. You collected the information. So in this case, there is no implied condition as to fitness. So a buyer is not depending on the skill and judgment of the seller. He has collected information and the buyer is asking for a special branded product or a patented product. Here also one case is there, Chandler versus Hopkins. It happened in 1938. So request was to send a patented furnace for the buyer's brewery. So here item was not suitable. So here the buyer is selling that I want that furnace for the brewery. That means he know that patented product he is asking. So here you have to remember that seller can recover the price from the buyer, because he came for a branded product. It's his duty to check that whether it's suitable for his office or accommodation or business establishment. Since he has not communicated, seller cannot be held responsible. Here you have to remember that most of the cases, let the buyer beware. Otherwise, we has to mention the special case to the seller. So that is how the general rulings of the Sale of Goods Act. The fourth point related to this is that item can be used for multiple purposes. See, if you're buying a cloth, it can be used for stitching. It can be used for stitching uniform. It can be used for as a tablecloth, table linen, table mat, so many different purposes. So buyer has to tell the seller the particular purpose. An item can be put for multiple purposes. So I give you the example of the clothes purchased. If not, the buyer cannot hold the seller responsible for that. Here also, in one case is there, John versus Padgett, 1890 it happened. You have to remember 2023 also, we are learning this case with all importance. So the cloth purchased. So here, you have to remember the cloth purchased, he has not mentioned he is going to use that for uniform. He has not mentioned that. So what happened? When they purchased, it was not suitable for uniform. So here, he cannot keep the seller held responsible for that, because cloth can be used for multiple purposes. The buyer has to make known his intention to the seller. Then only seller can select something reliable or related to the buyer's request. Now the fourth point, main point, condition as to merchantability. If goods are purchased for resale, the buyer should be able to sell that item to the other people. It should not be free with any defects or anything like that. Now, the buyer will be able to sell the product to the others. Now, if goods are purchased for self-use, it should be suitable for our own use. Now, there are also certain conditions required. So, goods are bought by description. He is giving the description of the goods purchased. Then the seller should be a dealer in goods of that description, a pharmaceutical industry or pharmaceutical shop if you are going for buying medicine, a cloth merchant selling clothes or anything related to that. The seller is dealing with the goods of that kind. Then the buyer has got an opportunity to examine the goods. If you're buying clothes from a shop, we will go and check that. We will see the item, we will touch, we will see the color, we will ask whether the color will go when it's washed, what are the washing instructions, all this, then only we will buy that. Now here also, Thornett versus Beers and Companies 1949, the case is there. This is an important case, 1949. So Thornet purchased glue. So this glue was stored in the seller's godown, and the seller is giving the right to examine the glue which is kept in the seller's godown. The buyer got the right to go and examine the glue, but the buyer was in a hurry and he didn't bother to check the glue which is kept in seller's godown. So here seller is giving the opportunity to the buyer to check that item, but buyer is not utilizing. So seller is not responsible, as the opportunity to examine the glue was given to the buyer and he has not utilized. Now the fifth condition is condition implied by custom. So here custom meaning, in this case, so many things we buy. When you don't have to mention the use for which we are buying, that example, feeding bottle, wheelchair, trolley, all these are examples. You don't have to go and mention that why we are buying that item. So in this case, if you're buying such things, the buyer need not specify the purpose of purchase to the seller. It's understood by custom, by tradition. So here also, Dr. Barreto versus Mr. T.R. Price, 1939 case. Mr. Price bought false teeth, but found not suitable for Mr. Price's mouth, and Mr. Price got every right to reject the goods, because when he's buying false teeth, he need not mention that what he's going to use for. As a dentist, it's his duty to know that. He has to know that why he's buying the false teeth. So dentist should know the purpose for which it is purchased. Now sixth point is sale by sample. This is mentioned in section 17 of the Sale of Goods Act 1930. So the implied conditions, sections 14 to 17 of Sale of Goods Act is explain the conditions. So bulk items, there are certain conditions for this. One is bulk items purchased should correspond with the sample in quality. Whenever when we go and buy something for our house, our own use, we check the sample and we will take that item. So that is, we are getting a right to check that item. But when we buy the item, it should correspond with the sample. Now buyer should get an opportunity to compare the item with the sample. Now goods shall be free from any defect which is not apparent on reasonable examination. So if the same sample, whatever we are checking and we are approving, that only should be coming as the purchased item. Now the last point, condition as to wholesomeness. That is, this implied condition is only applicable for eatables and provisions. So when you are buying something, eatables and provisions, that you have to remember that Consumer Protection Act is also very powerful about that. It's very important. Whether you're vegetarian, that green symbol should be there. Whether it's good for children, whether it's whatever the age, whatever the contents, everything will get the information in the packet itself. The details will be available. Price, when you have to use this, what is the time you can keep it, whether you have to be refrigerated or not, all the details will be there. So here also one case is there, Frost versus Aylesbury Dairy Company Limited, 1905. So here milk purchased from dairy was contaminated. We know that when we buy the milk, it should be the pure milk, everyday milk, the pure milk. If you keep it for longer, it will have its own problems. So Mr. Frost bought that milk and his wife died of drinking the infected milk. So the dairy company is held responsible. We have to be very careful. Now people are also very important and they are taking this as an important decision, because what they consume, what they eat, the seller has the responsibility for that, because it may affect the health of the person who's taking it or consuming it. So it's very important. So these are the conditions I want to explain in this module, and we have completed the topic with this explanation. Thank you. Happy learning.